Good afternoon, everyone. Thank you for joining us for today's session on Legal Complexity and Access to Justice, the Role of Law Simplification, a seminar organized by the Center for Asian Legal Studies at the National University of Singapore Faculty of Law. My name is Jaclyn, and I'm an associate professor and the director of the center here. The Center for Asian Legal Studies, if you may, was established in 2012 to consolidate and advance the faculty's expertise and commitment to the study of law in our region. And part of our mission is to provide greater exposure and raise the levels of understanding in critical aspects of law for the legal profession and legal academia. We run several key initiatives. Allow me to mention two. One is the virtual roundtables on Asian law, and the other is the Applied Law in Asia series. The virtual roundtables was kickstarted in 2020 when it became clear that borders were closing and we wanted to pivot online. And so the roundtables bring together legal experts who share critical perspectives on topical issues on law in Asia. Some of the topics we've addressed include COVID-19 and data privacy, sustainability and corporate mechanisms, comparative criminal law, as well as constitutionalism and megacities. Our first run of the Applied Law in Asia series was actually on comparative corporate law and governance in Asia, and we will be running another session under this series on civil law traditions. If you're interested in legal content relating to Asia, as well as some of the work we do, please do sign up to our mailing list to keep updated. Now, we are very proud to be able to offer today's seminar as part of our outreach and service to the legal profession. When it was announced that the Law Revisions Commission and the Attorney General's Chambers had completed a universal revision of Singapore's Acts of Parliament comprising some phenomenal 500 statutes, it was clear that this is a tremendous achievement on the part of all involved, something that deserves greater attention. Among others, the major revision was aimed at improving access to law, and we are very happy that we are able to collaborate with Ms. Jeanne Lee, Chief Legislative Counsel with the Attorney General's Chambers, to provide some insights into this process, its aims, its achievements, and also to explore the implications from multiple angles, including from the perspective of legal academia, litigants in person, and legal practice. And so we have with us today an illustrious panel whom I will now introduce briefly. You can find their extensive bios in the publicity materials that you receive. Ms. Jeanne Lee, as I mentioned, is the Chief Legislative Counsel with the AGC. Her department, the Legislative Division, has been overseeing the Universal Revision project initiated as part of the Plain Laws Understandable to Singaporeans, or PLUS project. Associate Professor Helena Whalen-Bridge will be our second speaker. She's an associate professor at the National University of Singapore Faculty of Law, where she teaches legal ethics and advanced skills courses. Mr. Leonard Lee, who will be our third speaker, heads the Community Justice Center, a community partnership between the public sector, the philanthropic sector, as well as the legal profession, rendering assistance to litigants in person. Ms. Rachel Tan will wrap up the formal session of today. She's an associate counsel at Rev Law LLC and is part of the leadership team at the Singapore International Dispute Resolution Academy based at the Singapore Management University. Now, a word on sequence. I've already mentioned the sequence. In terms of procedure, if you have any questions, please feel free to write them down using the Q&A function. You can find the icon on the right lower side of your Zoom screen. You may also use the Q&A function to upvote a question. As we're using the webinar function and not the meeting function, you will not be able to ask your questions orally. So please do use the Q&A function. We apologize in advance for this. However, this way we are able to accommodate more participants in a more organized fashion. And so once again, thank you for being part of today's session. I will now hand the time over to Ms. Jeanne Lee. Jeanne?
Thank you. Good afternoon. Thank you all for signing up for this talk. The response to this has been quite overwhelming. Thanks also to Jaclyn, who has invited me to share about the Universal Law Revision Project in the context of access to justice. Right, my talk today covers the law revision exercise that we did in the context of making laws more accessible. I recognize this is only actually a part of the wider topic of access to justice. However, access to the law, the legislation, knowing your rights and obligations is a very key component of access to justice. And in my case, I can actually only comment about this small part, which is access to legislation, because it's directly within our purview. Right, our starting point is that accessible legislation is the bedrock for the rule of law. People need to know what the law is. The law must apply universally, be stable. So you can see this in the vision and mission statements of AGC, that it's really about ensuring accessible legislation to ensure the rule of law. And this, for us in the legislation division, is the key mission. In 2013, the legislation division under the former Chief Legislative Counsel, Mrs. Wee Beng Kee, embarked on a project to improve and modernize the Singapore Statute Book in terms of its content and design. The PLUS initiative, or Plain Laws Understandable by Singaporeans, set out to modernize legislative drafting, improve the readability of our laws, improve accessibility to laws, and embark on the next universal revision of laws. So the universal revision was actually part of the PLUS project. There were a few parts to the initiative, as mentioned. One, to simplify and modernize the current drafting style. And secondly, to provide free, publicly available online access to all Singapore laws. This we did via the revamped Singapore Statutes online website that was launched on 15th of December 2017, and as well as the revision of all laws to bring the older laws in line with current drafting styles. Okay, sorry, just to go back to the earlier slide about the PLUS project and the 3 prongs that I mentioned. As I was saying, the PLUS project had different prongs, and it was really a review to try to make laws accessible. So as I mentioned, part of it was changing the current drafting style. Part of it was giving online access, and then because there's a whole existing body of existing laws, we did the revision as well to bring them up to speed with the current drafting style. So next slide. At the outset, I should say that law revision is not new. Next slide, please. It has been done regularly for new acts and heavily amended acts up to about 2012, but a universal revision has not been done since 1985. Could I have the next slide, please? Okay. Right, so the 2020 revised edition was prepared under Section 4 of the revised edition of the Laws Act. And there are 6 law revision commissioners. The Attorney General is the chairperson of the Law Revision Commission. We revised 511 acts, actually, so 510 in the 2020 and 1 act in the 2021 revised edition. And that was approximately 27,000 pages, or 31,226 pages if you include the complementary material. In contrast, the 1985 revised edition had 387 acts, with approximately 8,000 pages. So you can see that the size of the statute book has more than tripled. The revised edition in 2020 is also the first one to be published simultaneously in hard copy and online. Just to put things in perspective, the core team actually consists of 10 persons only, 2 drafters, 4 editors, 4 editorial assistants. But all the drafters in our division, about 30, were involved in reviewing the proofs. And in the last 3 months, almost everyone in the division, about 30 others, were roped in to help with checking the proofs and so on. So it was really a cooperative effort with all hands on deck. All the legislative amendments to acts in force up to and including 1st of December 2021 have been incorporated in this revised edition. The date of operation of the 2020 revised edition is 31st December 2021, and it omits acts that are spent, obsolete, or temporary in nature, like the COVID-19 Temporary Measures Act 2020. Okay, next. Okay, let me go through some of the key features of the 2020 revised edition of acts, and you'll notice that the features go towards making legislation accessible, not simplification alone. Next. All right, when we came to revising the acts, we realized that the statute book is not homogeneous. In fact, it is a very rich tapestry that reflects our unique history as a nation. In the course of revision, we felt it would be a shame to lose this diversity in history and to make all the acts read in the same way. So we therefore devised different treatments for different categories of acts. First, we have a category called special acts, which we largely preserved untouched due to their special nature. In this category are our constitutional documents, namely the Constitution of the Republic of Singapore Independence Act, and Independence of Singapore Agreement. The latter two are historical documents that we preserved in their entirety exactly. You have Imperial Acts, Maritime Conventions Act 1911, Straits Settlements and Johor Territorial Waters Agreement Act 1928, and these we also preserved. Then we have private acts and ordinances such as, Little Sisters of the Poor Ordinance or Central Sea Gurdwara Board Act. These are mostly enacted during the British rule and established certain private bodies to hold land. And we have the English Acts, which were commercial acts, which were received into Singapore law by the application of English Law Act 1993. And these were received as at 12 November 1993. So for these special acts, we by and large preserved their structure and language. Okay, then we have the vintage acts. These are acts enacted before and included in the 1970 revised edition. For this class of acts, we also applied very minimal revision changes so that the style and the language of the act are preserved. So for instance, we did not apply gender neutral language or replace the word shall. Many of these were drafted in a certain style. They were enacted pre-independence under the colonial government, or they were extended to Singapore when we were part of Malaysia. We wanted to keep that sense of history in the style and the language of these older acts. And 1970 was used as the cutoff because it was the first revised edition post-independence. And the rest of the acts, public acts, we applied a full suite of revision treatment to them. However, in doing so, our overarching concern and what we were always mindful of at the top of our minds was the risk of changing meaning. So we took extra care, and there are certain acts which certainly we know are very important in terms of the consequences that they can carry, and they can affect vested rights. And with these, we were extra careful. We basically checked them once, twice, three times. We passed them through more than one commissioner because of the risk of inadvertently changing meaning. Okay, so I was going to do a pop quiz with you, but I realized that none of the participants can actually respond. So I will just ask you the question, and you can guess it for yourself. Okay, which is the oldest act on our statute book? Okay, since you cannot answer, I will answer for you. It's the Wills Act 1838, and if you know it, it is actually an Indian act. And we do have acts that have Indian origin, like our Penal Code as well. These were brought in also very early in our history as a nation. So you can see what I mean by our laws really reflect some of our history as well. Okay, next slide, please. So I will explain this about the new citations of the acts because I think we've had quite a number of questions about removal of the chapter numbers and the addition of the year of enactment to act titles. If you look at the picture at the bottom, this is a classic example of the issues that we face with chapter numbers, right? So chapter numbers are assigned when acts are revised. Depending on when the revision was done, the acts are arranged differently. All right, so as a result of that, the chapter number of the same act can change over the years. 1970 revised edition arranged acts thematically in 5 volumes, whereas the 1985 revised edition arranged acts alphabetically. Now, if you look at this picture below, this is taken at a bomb shelter in Tiong Bahru. The Environmental Public Health Act, Chapter 155, is not Chapter 155 anymore. Even before the 2020 revised edition, it was not. It was Chapter 155 in the 1970 revised edition, but in the 1985 revised edition, it became Chapter 95. And then it was repealed and reenacted in 1987. So it was a completely different act, but it continued to be called Chapter 95. So we have moved away from chapter numbers, and we have inserted the year of enactment for a few reasons. Chapter numbers change over time, they get recycled. There is also no way to distinguish between repealed and reenacted acts. So today, the Environmental Public Health Act is called Environmental Public Health Act 1987. It distinguishes it from the earlier version of the EPHA. By doing so, we've also removed the need to revise an act in order to assign a chapter number. So going forward, there'll be no difference in the citation of a revised and unrevised act. And in any case, we found during a survey that we did that actually not many people use chapter numbers. So in case anyone wonders, that's a short summary of why we removed chapter numbers, and we have inserted the year of enactment. And you would also have the answer to the pop quiz I asked you earlier as to which is the oldest act, because you would know then that the Wills Act was enacted in 1838. Okay, next slide. Legislative history. Okay, legislative history is found at the end of every act. This is a service that the Law Revision Unit AGC started to provide sometime in 1996 to help users trace the history of the act. The team for the 2020 revised edition, however, has taken it to a whole new level by tracing back to the original enactment and even to predecessor acts. So every instrument that affected the act is recorded with the relevant dates and instrument number, and the predecessor acts are shown where applicable by diagrams. Okay, next slide. If you look on the left, the image on the left shows what the legislative history of an act looks like in the previous edition. Okay, it starts from the current act in force. So for the Criminal Procedure Code, it started from the 2010 enactment, but in the 2020 revised edition, we have expanded the legislative history. It's not just the history of the current version of the act in force, but also the act's predecessors. So the Criminal Procedure Code legislative history will contain details about the Criminal Procedure Code that preceded the CPC 2010, and the relationship between them is shown diagrammatically. So you can see that the various enactments are shown as predecessor acts. Okay, next. Right, so in cases where there are, well, you might call them mergers and acquisitions, these are shown, we read them from left to right. Okay, the earliest enactments are on the left, and the current enforced version of the act will be on the right. The boxes are labeled Part 1, Part 2, and Part 3, and so on. So the legislative history of each act listed there will be found in those parts, respectively. Because of space constraints, the diagrams can only reflect 3 levels of predecessor legislation. So any older enactments will be found in the details under the respective part. So you'll see that the part will then break out into the details, and they will trace each act that is listed there. This has been a project that is more than 5 years in the making. The team has dug very deep into the history of all the acts. There's approximately 10,000 individual entries provided across all the acts. And I'm particularly proud of the team for doing this, because it has taken sheer hard work and painstaking research to put all this together. And we know that whether you're a law student or a practitioner, there are times when you need to trace the history of an act, or you need to trace the Hansard. And so the relevant dates and the instrument numbers are all there provided for you to do so. Okay, next. Right, now we come to the actual text of the legislation. As mentioned earlier, we tried to bring the drafting closer to the plainer drafting style of today, but as you will see, there are some good reasons for leaving it unchanged in certain cases. So I'll just go through some of the changes we made. The full list is actually found, it can be found on the AGC website and also on the Singapore Statutes Online. It's in a guide to the 2020 revised edition. Okay, right, let's talk about gender neutral drafting. We have so far relied on the Interpretation Act for words in the masculine gender to include females, but we, in current drafting style, have changed to expressly include the female gender. So he becomes he or she, or we will refer to the antecedents such as the employee, the licensee, or the person. Chairman, we change to chairperson. Authorities such as superintendents of prison or minister or controller of income tax, all these contemplate either a man or a woman being appointed, and we will make those changes accordingly. Okay, other techniques we used were letter pronouns, A or B, or terms such as the first mentioned person. Okay, the challenge here, which we really faced, was to ensure that in all cases, the correct pronoun was used. There were many instances where we had to ask ourselves whether the word he included a legal person, that could be a corporate entity, or was it just a natural person? If the person is a person within the meaning of Section 2.1 of the Interpretation Act, this will include corporate and unincorporated bodies, not only a natural person. So it would have to be changed to he, she, or it. And then there were occasions where we were not sure. And then in some acts, there were so many persons in the provision that it was really very challenging to figure out who was being referred to, and basically it involved very careful reading and rereading to ensure that we did not inadvertently point to the wrong person. Plain English, we've also applied more plain English in this revised edition, making substitutions like notwithstanding change to despite, or using without limiting in place of without prejudice to the generality of. We've removed some archaic words, as you see there, here and before, changed whilst to while, therein, thereat, and so on. But there are certain words we did not change. Note that we did not change words like prima facie, ex officio, inter vivos, pro rata, and so on. We did not change these because they have an established meaning. They're actually well-known terms, at least to lawyers. We did not change terms used in land law, for instance, which have very established meanings, like conveyance or encumbrance, requisitions, easements, even though the terms themselves may arguably not be simple, but they have a very, very clear and established meaning, which we did not have any decent substitute for. Right. There's word shall, very fraught. We have in current drafting style moved away from using the word shall. You may have noticed this. We have endeavored to be clear as to whether we are talking about an obligation, is something mandatory. So do you mean must? And if so, we use must. So the old formulation, no person shall, for instance, sell fireworks without a license, we would change to a person must not sell fireworks without a license. Or shall can be declaratory, and then we would change to is. So for instance, the decision of the minister shall be final would be changed to the decision of the minister is final. We use is to as well for matters involving the court. So we would say the court is to consider, for instance, all the circumstances of the case. Okay, we did not change shall for penal provisions and liability that is to be found by a court. There is very great risk with this, in inadvertently changing punishment provisions. There is a cautionary tale which we tell to everyone, a real case that this was done. So we don't change this, and the courts are familiar, and there's a great body of case law that has already built up around this. So so that was one area we did not touch. Disability terminology, that's to be in line with MSF's Inclusive Communications Guide. So we changed mentally disordered person to a person with a mental disorder. Okay, next. And my time is running on, so I'll just quickly mention these. We remove some unnecessary words. So where you can rely on section 2.2, for instance, we would remove those other words appearing in other acts. From time to time, we can rely on section 27.1 of the Interpretation Act, which says that where written law confers a power and imposes a duty, then the power can be exercised or the duty performed from time to time. But we don't remove from time to time where it refers to a duty. For instance, you must report something from time to time when required to do so. So it's not just a cut and click, replace. In his discretion, again, we remove it sometimes when you don't need it. The discretion already lies with the decision maker. The decision maker may do something, but we do not remove it in special cases. For instance, the president, where the words denote that the discretion must be exercised personally and not on the advice. Okay, and doublets, we just remove some as well. Okay, next. Paragraphing, this is just to show that even without any change in words, by breaking up a provision, it can make it much more readable. And this is what we did here. And in the next slide. Next. Yeah, so this is, yeah. And then just a word to say that we did some renumbering, and you can find the previous numbers in a comparative table that is found at the end of the Act. Next. And also, at the end of a section, you will see a little square bracket, and that refers to the previous section number. Okay, next. All right, so in conclusion, I just wanted to say that we found that plain language does not always mean the law is simple or comprehensible. Why? Because the law itself is not simple or comprehensible. The subject matter may not be. Best example of this really, to me, is in tax legislation. The words are very plain. Tax is payable when, or there is allowed a deduction of whatever. But the subject matter is not necessarily very comprehensible. And likewise, the legal jargon is sometimes actually more comprehensible than trying to simplify. So simplification does not always lead to comprehensibility. So for instance, as I mentioned earlier, prima facie, it's a very well understood term. We cannot try to simplify that because people then actually may not know what it means. And secondly, my other thought was that accessibility is affected by much more than a change in just language, textual language. I hope I've tried to demonstrate some of the efforts we're making to achieve accessibility. And in this context, access to justice, which take even more effort, which I think the latest speakers on this panel have made their own significant contributions, and I'm looking forward to hearing from them. Right, thank you.
Thank you, Jeanne. Wow, I must say, having heard what you've just went through, it is an even more phenomenal achievement what you have done. I mean, just looking at the legislative history part, having done some work on trying to trace some statutes to their legislative history, pre-colonial ordinances and all of that, that itself is, so much work has gone into that. So congratulations to your team. We'll now hear from Helena, who will speak a little bit about these broader issues on access to justice. Helena, on to you.
Thanks, Jaclyn, for the introduction. Thank you so much, Ms. Lee, for giving us that overview. And thanks very much for participants and your interest in the subject. It did really seem like this subject would have wide-ranging interest because so many legal actors deal with statutes. I think everybody does at one time or another. So comprehensive changes certainly affect many people. And we're now going to shift the discussion a little bit to the interaction between a statute simplification and access to justice. And I'll be providing a little bit of context for that. So I'll share a screen now. And hopefully everybody can see the PowerPoint. Okay, so I'm going to be talking about basically 5 different points just in a few minutes. I'm going to start with the litigant in person experiences and talk briefly about why the law is so difficult for laypersons to understand and what the scholarship kind of tells us about that. I'm also going to touch briefly on the idea that many of us have, that of course ignorance of the law is not an excuse to avoid liability, but that really has somewhat limited application, at least in some contexts. And that has led to some principles of law simplification. And we're seeing those in vivid color in the simplification of statutes, Singapore statutes. And then I'll wrap up my remarks by putting this simplification into the context of the other innovations that Singapore has taken for access to justice. Okay, so let's just begin with maybe putting the law simplification and access to law in the context of access to justice, and in particular, LIP experiences and how litigants in person might struggle to understand law. So the terms that we normally use for someone who is not represented would be a litigant in person or even accused in person in the criminal context in Singapore. These are the common phrases, and they focus on unrepresented parties in court. So what difficulties do these people have when they're in court, when they're trying to understand the law? There has been research by Jaclyn and myself on this, and so I'll just share briefly some difficulties that litigants in person have. Their experience when they go into court is frequently difficult, and it can be extremely difficult for somebody going into court without a lawyer. The issue, first of all, bringing a litigant in person to court can be quite serious. It can be potentially also an emotional matter, which then is additionally difficult for a litigant to handle, such as custody of children. Litigants in person are also trying to resolve this issue, this very important issue perhaps, in a venue where the language and the procedure are foreign. I mean, they literally do not understand the words being used. Of course, there are many sources of support for litigants in person. This includes court personnel, as well as the Community Justice Center's many services and other legal actors as well. But the litigants in person that we interviewed reported expending considerable time and energy into just finding legal resources and then trying to evaluate different legal resources, because of course they don't know what is better quality or worse quality legal information. And then trying to comprehend that legal information, as well as attending court and submitting documents. And all these things can snowball and make it difficult for the litigant in person. It affects many other areas of their lives, at least potentially, such as employment and other responsibilities. Okay, so these are the terms. This is the experience just in a nutshell of a litigant in person in court. But of course, we know that most people in society are lay people and that they still, whether they're in or out of court, they need to know some aspects of the law. I'll talk about the hamburger in a minute. I know we're kind of getting on to dinner, but I'll get to that in a second. Now what we're talking about is, why do lay people have such difficulty understanding the law, even when it seems relatively clear? The literature suggests three main reasons. One, of course, is that applying the law requires a process of legal analysis. This is just what law students are taught in law school and what they hone when they go out into legal practice. It's not just being able to read the English words, it's applying the process of legal analysis to really bring insight into how the law applies to you or your case. And that applies to case law, for example, even discussing what the relevant facts are, what the holding is, and how it might apply to your case takes a process that lay people probably don't have. And even statutes have to be interpreted according to sometimes competing principles of interpretation. The second problem that lay people encounter when they try to understand the law is our specialized vocabulary. And this was also mentioned in the previous remarks. It's what is sometimes called legalese. But of course, this also has benefits. And that's another theme or kind of point which came up in the previous remarks. legal language allows at a minimum precision as well as efficiency, because of course I could, and we probably could explain even complicated legal concepts to a lay person, but it's not a fast food burger. Here's where the pictures come into play. It's really a multi-course buffet, right? Or multi-course dinner. So, and that leads us into legal knowledge, and really understanding legal knowledge gets us into the third difficulty that lay people experience, which is that the law and legal concepts are really nested concepts. So concepts within concepts. And of course, if we know them, then we can be precise and very efficient about things. But if we don't know them, then you're doubly on the outside or triply on the outside. So for example, innocent until proven guilty, at a minimum, probably that would include concepts such as presumption of innocence, burden of proof, the concept of making a distinction between procedural and substantive rules. This example would probably also be in a constitution. And what's the difference between a constitution and other laws? What are the actual constitutional rules? How are they balanced? Okay, so lay people have difficulty understanding the law for at least those three reasons. Those are probably the main three reasons. Well, what about, though, this concept that everyone is supposed to know the law? This is really an ancient principle that ignorance of the law is no excuse, at least for certain kinds of liability. But it's not, this idea does not apply without limitation. And so even in criminal matters, probably the relevance of this principle would depend on the context of particular offenses. And we also know from the research that's been done that law and procedure are explained, at least to some degree, by judges and other legal actors when litigants in person go into court. And if we can just briefly compare the medical field, which my view is that this really isn't done enough. And it really helps to make sense of kind of the difficulties that we run into in the legal field. Some knowledge, of course, of medical issues for your own health and safety would be, I think, reasonably assumed. But once we start to get into more complicated matters, I don't think anyone would expect the person on the street to have this knowledge. So, so what is it that people are supposed to actually know about the law without much help, or at least without help from a lawyer? I think we could say that most people should be able to read and understand at least certain areas of the law without the need for professional assistance. Okay, and this has led to the development of at least some principles of law simplification, or the simplification of complex technical legal information into more readily accessible legal information for lay people. And I'll just give a couple of those principles. One would be to try to prioritize and select key portions of the law that a lay person has to know. Not all the detail is really relevant for the questions that they're going to have. And then the other principle would be to use lay terminology, not legal terminology, but if an acceptable degree of precision and efficiency can be reached. And I've just included a screenshot of the Singapore Small Claims Tribunals page to give you a sense of kind of modern approaches to law simplification. So really what we're saying here is that access to justice in terms of access to law means prioritizing key portions. And what that means is that there is going to be some loss of precision and detail. Okay, so the kind of getting to the end of my remarks, I just wanted to put the innovations that Singapore has made into context, because one of the themes, one of the reasons for doing law simplification in the recent Singapore revision of Singapore statutes is to make them more accessible to people who are not trained in the law. And that move really needs to be seen not in isolation, but in the context of many different steps that Singapore has taken over the years. And just some of the highlights post-independence might start with the Small Claims Tribunal in 1985. Also, we have more recently the Community Dispute Resolution Tribunals. There are many brochures, websites with information that are now communicated in a much more lay-friendly manner. There's also the online submission of court documents, which I know that many of you are familiar with. What you may not be familiar with is a very important step of automated court document assembly, some of which has been done in concert with the courts and the Community Justice Center. We also have court navigators, also sometimes referred to as Mackenzie Friends, and Singapore's own version of that, the Friends of Litigant in Person from the Community Justice Center, and also Community Justice and Tribunals Division Friends Scheme. And now we can very happily add to these steps the simplified statutes. Okay, so to conclude, Singapore has already made significant progress in access to justice and access to law. And now with the revision of the Singapore statutes, where might we be headed? What kind of still do we need to do, arguably? Well, the statistics are always going to be helpful to ensure a well-based reflective decision about any kind of action. So in particular, statistics on litigants in person and their accessing the statutes would be quite helpful. Also, I mentioned some principles of legal information or law simplification, and there is work being done on this, but there's really no how-to manual. And we've seen that this kind of work is really very complex, and there's a lot of discretion involved. But I think we probably could share lessons learned a bit more widely, because many jurisdictions are doing this kind of work. And then lastly, we would urge, or I would urge, a revised concept of the litigant in person. I think, and as supported by the simplified statutes that we're talking about today, which means that people wanting to understand the law and read it is not an anomaly. But we are rightful participants in the law, whether we're lay people or lawyers. And this is based on a belief in law and justice that should arguably be valued. Okay, that's all for me.
Thank you, Helena. Without further ado, we will now go on to Leonard.
Okay, good afternoon, everyone. Okay, I'm going to make this a little bit different from what I originally want it to be. Okay, so this whole topic is about law simplification. And as what Prof. Helena has just mentioned, okay, that laws are generally meant to promote order and stability of a country. Okay, so I think it's then even more important, okay, that we need to hear from those who are expected to obey them, okay, the lay persons. So what I'm about to share today, okay, are actually feedback that I have gathered over the past 2 weeks prior to this talk, okay, from employees, volunteers, lawyers, and court users. Okay, so what does it really mean, when we to a lay person, when we talk about law simplification? Okay, so from their perspective, okay, it simply means that the complexity of the legal processes and language is made simple enough so that the average man on the street can understand and to use the law effectively when appropriate. So I believe that the public in general is fully supportive and understood the importance of simplifying the language used in law. However, I think simplifying the process are just as important so that legal users can have the option to navigate through the process on their own. The justice system can also be further enhanced, okay, by supporting the ease of use through adopting a right door policy, okay, so that a user can be directed to the appropriate resources for their legal case. So all of this can be supported with the use of technology. Okay, so the language of law should not be foreign to the ears of those expected to obey it. Okay, so these are actually just some examples of what litigants view as challenging to them. Of course, these examples are really varies with their educational level and emotional state. So many have problem understanding, okay, how to fill up their affidavit and even to interpret one. Okay, some are frustrated with the language used by law firms. Some find the legal process complicated. Of course, there are also those, okay, who only wants to hear what they want to hear from the judge. Okay, as what Prof. Eugene Tan has recently put, the laws that are clear also help to reduce the need for litigation to resolve what is the meaning of a term, a clause, a provision in any piece of legislation. Okay, so here are some further problems faced by litigants and how the CJC, that's the organization that I head, it tries to address them. So at the CJC, we have help centers that is located in all the 3 courts, okay, that provides information on court processes and free legal advice. Okay, we also have low bonus schemes, befriending services, social services, such as providing interim financial support for those for needy litigants in person, food rations, and even counseling. And of course, with support from judges and lawyers, we also have simplified guides for court users for various matters. So past few years, we have also designed technology-enabled assistance, okay, such as the interactive infographics and automated court documents assembly systems. So one key point that what I would like to note, okay, is that the simplification of law, okay, is actually not the same as a change in concept, principles, or case law decision. Yes, the simplification will lead to more people understanding the law, but not take away the important role that lawyers play today. Okay, I've gone through 10 years of working at the CJC and with LYPs, and I dare say that simplified procedures currently are usually effective for just a small value and uncontested claims, or similar simple cases that do not merit a full procedure. Okay, you normally have lower threshold, lower court fees, lesser documentation, and does not merit the need of legal representation. So during my interview with some lawyers, okay, there are some who are actually quite skeptical about this whole movement towards simplification. However, I would like to assure them and to some of you out there that you still have your work cut out to be. Okay, this is not it's not going to change everything overnight. Okay, so it is like, I mean, I'd like to use the 3 examples I put out there. You know, it's like someone who wants. Could you try again? Someone who wants to be a apprentice overnight. Okay, but you know you can't, right? I mean, it's like you take years of training to become apprentice, just like a lawyer. Okay, and I'm sure many of you travel, and depending on where you are, there's some, okay, like myself, okay, we actually engage a local guide if I do not speak their language and I want to get to know the place better. Or when you're climbing a mountain like the Himalayas, okay, it is unlikely that you will be able to complete the climb yourself and without the guide or a Sherpa, okay, who can help in carrying your bawan, you know, your burdens, and also set the directions to complete the climb. So lawyers, you're actually very important in this whole process. So finally, I would like to share, okay, a real story about a 67-year-old Mr. Ang, okay, as actually asked them a question about what does he think about the simplification of law, okay, and he feels that it is very important to a lay person, and this is what he perceived. Okay, so Mr. Ang was a self-employed contractor in the 1980s. He only possessed a Primary 2 certificate, speaks very little English, and was widowed when his 4 kids were still very young. So he has been charged in court for fatal lorry accident caused by his worker and eventually sued for bankruptcy. So Mr. Ang was stressed at the time with financial difficulties, suffered a mental breakdown due to the death of his spouse and having no money, okay, to support his 4 school-going children. So he even traveled the whole of Singapore, okay, seeking for social and legal assistance, but received none. Okay, so this is what he has to say when I shared with him about what does he think if we were to simplify the law. So back in those days, that's what he said. Where is there any agency or place like today that can provide the social and financial assistance I need? Who will help me with my losses when I can't pay them? Even if there was, nobody told me about it, and I'm not referred to one. If only there had been some assistance, some such assistance, I would have food and medical subsidies to provide my young children. And if the court process was not so complicated, I may even be better able to help myself, and life wouldn't have been so tough then. Okay, so with this, I will end my sharing.
Thank you, Leonard. Thank you. And now we'll have Rachel. Rachel, on to you.
Hi everyone, good afternoon. My name is Rachel and I am Associate Counsel at Rev Law LLC. In the 8 minutes that I have, perhaps I will round up this session by making 3 points and illustrating 3 examples from my own practice. If the question that arises is, what is the tangible effect on pro bono practice and litigants in person? Perhaps I would like to start right at the outset by agreeing with the panelists that yes, simplification of the law is not an explanation of the legal concepts, neither is it a multi-course buffet, right? But nevertheless, I would say that there are still some positive impacts that it may have, and I'd like to start off with my first example. First, making language of the statutes plain. What is the effect on the litigant in person? First of all, we would say, okay, so we don't have to show this slide. This slide will be referenced later. Thank you. So what is the impact of making the language of a statute plain? A lot of our clients are exactly litigants in person who face criminal charges. So when they first face a charge, they will see the particularization of the charge, namely the facts by which they have been given so that they know what they have done, and then a particular section of the statute which the charge falls under. So for example, it can be the Penal Code, it can be the Protection from Harassment Act, or some other provision of the statute. The litigant in person will receive a letter in the mail, as all of you know, with the charge, and they usually do not know where to find the legal answers. They have no clue about the relevant legal procedures, and they will tell you that they have heard anecdotal evidence from their friends, and a particular result has been reached. All right. So this means that even if they have some knowledge and they do not meet the test for legal aid, they are very much by themselves if they cannot afford to instruct a lawyer. So I think that this is where the language of a statute is extremely important. And I'll give you one practical example from one of the cases that we have. This was a case of a private prosecution brought by one individual where it was a charge was alleged under the Protection from Harassment Act. So here, what happened was that upon reading the charge in the first instance, the client disputed that the facts were correct. So that was a dispute on the factual basis of the charge. And then because the charge particularized section 3 of the Protection from Harassment Act, his son could actually look at the statute online and read out the particular section, which is actually very clear in plain English. Section 3 actually says that an individual or entity must not, with the intent to cause harassment, alarm, or distress, use any threatening, abusive, or insulting words or behavior, communication, or the third clause, publish any identity or information of the target person, as a result causing someone, the victim, harassment, alarm, or distress. So upon just reading, going online, accessing the statute and reading section 3, the client said, I didn't do it. I want to defend the charge. Let's get a lawyer. So eventually, the client was referred to us and we decided to defend the charges. So here is where the slight nuance comes in. The client is able to read and understand the language of the statute, but the client will not know how to defend the charge, which is the points that Mr. Lee and Ms. Lee from CJC and AGC made earlier, right? The client will not know, for example, that in a private prosecution, you can actually make representations for the public prosecutor to take over conduct of the matter. the defendant will also not know, I mean, the person who's facing the charge will also not know that there's actually a compensation clause if the person is eventually acquitted, and that is found in section 395(3) of the CPC. So CPC is a very, very long document, right? We cannot expect litigants in person to be able to read everything. So that's where I think the job of a lawyer comes in. This is the first example, right? The point is, the first part of the call is the statute, so making language plain is very helpful. Second point and second example is that many clients are actually not proficient in English. So we have clients who are foreign domestic helpers who have returned to their home country, or persons who speak vernacular, so their languages, which they usually speak, are Hokkien, Cantonese, and Chinese. So what we do is usually we have translators, or if we have no translators, I will actually have to attempt to do it myself, and I'm very sure that often I am not able to explain the nuances of the statute so clearly. But how we do it is we will read out the section of the charge or the statute to the translator. The translator will translate it to the client. The client will ask clarificatory questions and ask the translator, and then they will translate back. And then we will ask our clarificatory questions. And these actually, so for a very simple, let's say just to get through a very simple 10-page affidavit, the call might take 2 hours just because of this process of translation. So I think one of the areas in which law reform is helpful, particularly in the simplification of statutes, is where the sections are actually broken up. So we can just flash a section and point to it and say, look at this subsection. This is what I want to translate for your client right now. It is X, Y, Z. And that is something that we thought was quite useful. The third thing has to do with legislative history of the Act, and I think that was something that Jaclyn and Ms. Lee alluded to earlier. Why do we say that this is important? It's because it is a very tried principle of law, right? That tracing the legislative history of an Act is important because it gives effect to the presumption of Parliament's intent at the time of enactment, right? It endures until express parliamentary amendment is concluded. So we would like to illustrate the usefulness of having a very clear legislative history with one of the cases that we had as well. So in this case, we had a client who is a private hire driver. He was charged under the Road Traffic Act 1961. He lost his job during COVID, and he could only find employment as a gig worker, namely a Grab driver. So he was referred to us on a pro bono basis by a religious organisation, and he was willing to plead guilty. But the issue here was sentence. And if he were to be disqualified from driving for a very long time, it essentially means that he will lose his livelihood. So we had to make sure that the submissions on sentencing were good. When we looked at the Road Traffic Act 1961, our first survey of the case law indicated that the Act was pre-amended. Actually, it was amended in 2019. But if you look at the legislative history, here, if you could move on to the next slide, to the next slide for me, please. If you look at the legislative history, the Road Traffic Act has been amended quite a few times. But that particular amendment in 2019 is particular to the section that he was charged under. If you look at Act 20 of 2019, 30 October 2020, that section was the section that he was actually charged under. So after we traced the legislative amendments, we were able to make submissions to the court on the position pre-amendment and post-amendment, and actually we submitted that Parliament did not impose any minimum disqualification period, and we gave the court a framework, pre-amendment and post-amendment of the Road Traffic Act, in order to make certain submissions on sentencing. And in the end, we managed to get a relatively good outcome for the client. And I think the point here is this, that legislative history, which is set out clearly, saves counsel a lot of work in making accurate submissions to the court, in finding Hansard, the relevant Hansard, in tracing which sections have actually been amended or not. And this is important for pro bono practice, we would say, as even a very small reduction in sentence can directly affect the accused person. So this is all I have to say, and I'll now pass the time back to Jaclyn. Thank you.
Thank you, Rachel. And I believe Rachel has also written something along the lines of her presentation and in an expanded version, which could be published at some stage. So If anyone is interested, please feel free to write to Rachel for the publication. So thank you very much, everyone. We do have a few questions in the Q&A. So perhaps allow me to pose the first one to Jeanne first. This is from Alvin Chen, who asked whether the extent to which AGC referred to case law when interpreting the language of a statutory provision during this exercise. Jeanne?
Thank you for the question. Yeah. So we did. The short answer is yes. I would not say we read every single case on every provision, but I think wherever there was some doubt as to what the provision might mean, we did look at those. We would try to search and see whether there was any judicial pronouncement on it, or we would also look up, for instance, judicial pronouncements or certain words. So, for instance, we did not change the word forthwith to immediately, because forthwith has a meaning. So we just, we would leave certain words alone because they had been judicially interpreted.
There's sort of another question from Douglas McLean about the guidelines or approach taken in determining word choice and simplifying language. I think this is to Jeanne again. I believe you said that there is also there's a guideline, there's a guide that's published online on the AGC website. Yes.
Yeah. So we had various guides. We had internal guides, what we called standard changes that we should make, non-standard changes, and but as you can imagine, when you have 30 lawyers working on proofs, there's bound to be differences of opinion, and it was very, very difficult actually. So you've touched on one of our main challenges, which is maintaining consistency. We ended up, when we later looked at certain proofs, we found that the laws started out looking the same and then they became different, as in two acts which were enacted that looked roughly the same when they were enacted ended up looking different. So although there were guides as to the type of changes to make, and we had a very small team to actually make the initial recommendations for revisions. Every act had to go through a lawyer as well, and at least one law revision commissioner more if it was a high risk, considered a high risk act. So we had a lot of opinions going on, and as you can imagine, for a project that spanned more than 5 years, we also had changes of mind. There were developments over time. So there was a lot of revisiting that had to be done. I mean, eventually, we tried very hard and we landed on what we hope was as consistent a position as possible. And so the guide that came out when we published it was a summary, I would say, of the various decisions we took. It's not exhaustive. In the end, we just went very much with, getting an agreement, for instance, among the commissioners to align in a certain way, and then we just did so for consistency.
So just one further question with regards to the 2020 revision, and this is from Prof. Chan Wing Chung. In the event that the 2020 revision may have made an unintentional change to the law, will the court be able to look at previous versions of the law, or will the 2020 revision be definitive?
Right. So in the revised edition of Laws Act, does set out that the powers of the commissioners do not extend to changing the law, changing the meaning of the law. And so we have a case, real case, PP against Po Boon Kiat, where the court in that case dealt with a reprint of the Women's Charter, and those were powers. The powers to do the reprint are very similar to the powers to do law revision today. The court did go behind to look at the previous edition of the Women's Charter to see that a change made during the reprint from shall on conviction be punished to shall be liable on conviction to imprisonment. There's a change in meaning. Shall on conviction be punished is a mandatory punishment, whereas shall be liable is a power given to the court to impose. So the court actually construed that that since there was not intended to be any change in meaning, it read the previous version as the correct version, and it imposed the punishment accordingly.
Right.
Although that was based on a reprint, as I said, the powers exercised to do the reprint were later the same powers that are in the revised edition of law. So if we take that interpretation, I would think that the court would follow the same approach and go behind to read the enacted version, to read the act as it was, and to interpret that law revision could not have intended to change the meaning.
Right. Okay. So thank you very much. So we also have a question from Damien Chung, which is, I think, much more wide-ranging. So I'd love to hear also from Rachel, Helena, and Leonard, if you have thoughts about this, which is whether or not there is room for reconsideration of the purposive interpretation of penal statutes mandated by Section 9A1 of the Interpretation Act. And this is because the purposive approach may require the general public to undertake a rather difficult and uncertain approach to determine if the conduct is criminalized under a particular provision. So would a strict construction, as opposed to a plain language approach, be better in the penal context, since it's arguably simpler to apply? If you don't mind, I'll ask Rachel then to start with this. Rachel, what do you think?
My personal opinion is that we should keep the purposive approach, right? I mean, the framework for statutory interpretation in Singapore is Tan Cheng Bock and then the Interpretation Act, right? And the reason for that is because if the issue is directed at litigants in person or the common layman not being able to go behind the words of a statute in order to divine the meaning, that actually is not the lay person's job. And it is very difficult for a lay person to have, the 5 or 6 years of training that you have had in order to divine the meaning. And why? And so then the question is, then why is a purposive approach important? It is because it assists to confirm the meaning, right? The meaning of a statute is ascertained by going to why the statute was enacted in the first place. So, for example, if we look at let's look at the Road Traffic Act, which is a common statute, right? Why did Parliament impose revise the Act in 2019 to deter people from driving dangerously? I mean, the purpose behind that is a social purpose. There's a social policy behind it, right? But if we just look at the strict construction of the words, then it is quite hard, to make certain arguments that would be beneficial or not to your client. So I would advocate that the purposive approach would be, I mean, a purposive approach might not assist the layman directly, but it is still valuable to keep it.
Right. Thank you. Helena, any thoughts on this?
Yeah, thanks for that really interesting question. Just the thought of getting rid of the purposive approach, I think is a little startling, but and of course that's because we want statutes to achieve their social goal, right? That's we definitely want to achieve that. But I take the point that of course we want to also try to make the statutes as accessible as possible. It does seem that the short answer here is that there's just going to be a limit to the extent to which that can be done. And I guess the most infamous example of that would be, I think it's the Prussian Code, which tried to address every possible situation that might come up and ended up with, I think, 47,000 or 57,000 sections. And nobody wants that either. So I think, legal rules implicitly are going to have some ambiguity, even the positive law, the written law, and that's going to take some kind of interpretation, and that we probably want a purposive approach to help us do that.
Leonard, do you have, would you like to
yeah, I think Yeah, I think simplification is really limited to just a certain aspect of the law. You know, it can't be throughout, change everything. No, it's not possible. Yeah, so as long as it is some the law pertains to the common people. So those are the laws that should be there should be more focus on simplifying those laws as compared to the other laws that is not commonly used by people.
Right. I mean, obviously, access to justice is a wide-ranging issue, and some of the points that you have all raised, including sort of procedural simplification, and all of that needs to also come in. So we are sort of 1-2 minutes to the end of today's session. So I wanted Jeanne to perhaps also, if you have some thoughts about this question of whether the purposive interpretation should still continue to be the prevailing approach, and perhaps even whether in this work, whether the purposive approach actually was a way to assist in some of the choices that were made. So Jeanne.
Okay, so my quick answer to the original question was, I think we should, especially for criminal penal statutes, give the benefit of the doubt. And I wouldn't want, for instance, an accused person to be worse off than, let's say, someone, who enters into a commercial transaction, because they cannot have the benefit of a purposive interpretation. Then to Jaclyn's question about whether we relied on it, no, we try not to rely and say, oh, people are going to fill in the gaps with the purposive interpretation, because that actually means we haven't quite done our job very well as drafters. We should be actually drafting to be as clear as possible, so that we don't have to fill in the gaps. But of course, if there are, then then the courts should then fill in the gaps, and I wouldn't want to deny anybody that avenue as well.
Right, that is really important, because the tremendous job that has been done, I suppose, should be advancing sort of issues of justice, rather than sort of limiting or narrowing the avenues for justice. So we have come to the end of today's session. There are still a couple of questions on the question of Singapore law reports being made a public resource. I don't think it's up to us. So this will be up to the Academy. Unfortunately, we cannot go through all the rest of the questions, but thank you very much to all of you for being here today. And I hope you will join me in thanking, in your own little way, our speakers, Ms. Jeanne Lee, Dr. Helena Whalen-Bridge, Mr. Leonard Lee, and Ms. Rachel Tan for sharing their insights. So thank you very much. Have a good rest of the day.